And also family violence, there's a new
Pick.
case.
Pick.
Oh, it's Pick.
Yeah.
Hi.
So Judge, just the backstory. So I've been coming to court repeatedly on the family violence case. There's been I guess a case with Pick, or a couple cases with Pick that have been kind of percolating. And then he was indicted, I guess, on how many counts?
I'm gonna get out my
Okay.
multiple yes. Eight counts, Judge.
All right. And is that on the kidnapping?
Yes.
Okay.
So I've been appointed to those cases now. I don't have any discovery on them. So obviously, I think the discussion all along was those are going to be the cases we were going to try. I'm a bit taken aback by the 8 different counts, a little, I think, overreached by the previous prosecutor. But nevertheless, I'd ask for I guess, discovery deadline so I can try to get the discovery on those new cases and figure out what I'm doing with them. And then on a side note, he tells me when he was magistrated on the new cases, no bonds were set.
Mhm.
So, which I found kind of unusual, but I don't know who did the magistration, but I'd ask the court to set bonds on those cases. I don't see why he wasn't given a bond when he was magistrated.
All right. And this is on the newly indicted case?
Yes.
Yes, Judge, with the sport, with you have to report.
All right. Do y'all want to proceed with an oral motion to
Yeah,
set
I
bond?
would, Judge.
And State, are you prepared to proceed?
Make sure I have everything. I think this would be enough, Judge. I think you know,
All right. Thank you.
yes,
And
Judge.
what I can tell you is on the 2024 CR 0924 case, which is the assault family household. Let me see. Okay, he has a bond on that one.
He was out on bond when all with these new cases finally got indicted.
Okay. All right, the court is calling 2025 CR 013272, State versus Jonathan Dreamer. Can I have parties announced for the record for the state, for the defense?
Robert Mauer.
And are you Mr. Dreamer? All right, defense, are you requesting a bond?
I am, Judge. I'm requesting the court set bonds on the cases that he was magistrated on, but no bonds were set.
All right. Any objection to the defense having an oral motion to set bond?
None, Judge, but the state would like to proffer a report from this court's review.
All right, just one moment. Any witnesses?
No, Judge. I mean, I can tell you, look,
I'll
for
need,
purposes of the bond hearing, I guess I can call Jonathan Dreamer.
all right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
They need to speak louder.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jonathan Dreamer.
All right, defense, you may proceed.
Jonathan, I know you've been incarcerated
Just one
since
second, I'm sorry. Everyone, please whisper, we're on the record. You may proceed.
you've been in custody since you were picked up on these new charges, correct?
Yes, sir.
Do you, I guess, once you were arrested, you lost your job, is that correct?
Yes, sir.
Do you have any family who can help you make bond if you're given one by the judge?
Yes, my my niece and my sister.
Okay. And do you know how much money they have set aside or can get for bonds?
They don't make much, but I know they could at least get like 1,000.
Okay. And do you have bail bondsmen you can work with that you might be able to work payment plans with?
Cowboy Bill.
Okay. All right. I have nothing further to.
All right, state, any questions?
Mr. Dreamer, were you on bond in a family case when you picked up these cases? Or did these have to prior to the family case?
Judge, I'm going to object to any. I mean, if the court wants to review the records, I don't want my client talking about dates, but I think, well, the court's aware and there's judicial record that my client was out on bond. These cases were filed at large when we were coming to court, and then he got picked up once they got indicted.
All right, so here's the court's question.
Yes.
The case that he is indicted on that he doesn't have a bond for,
Yes, Judge.
what is the alleged offense date?
November 8th. And also November 8th.
Okay,
That might be a stenographic. error.
Yeah, that's an error.
So November 8th, 2023.
all right. And then the case that he previously had bond for, you're saying the assault family violence case, what's the alleged offense date on that case?
Yes.
Yes.
October 22, Judge.
Okay. All right, states you may proceed.
No additional questions.
All right, I have a few questions and it's questions that are related to bond. First, in defense, if you know the answer to this, you can answer it or your client can answer it. Has there been any type of mental health diagnosis in the past or any type of mental health medication that has been previously prescribed to your client?
There's nothing that I'm aware of. Did you have any sort of previous psychiatric?
No.
And there was, I know they do mental health evaluations at the jail, but I didn't receive any red flags
Okay.
on that at all.
And then my other question, in the past, has there been any type of drug use?
Not that I'm aware of.
No.
All right, any other questions?
None from the stage.
All right, any other witnesses?
No, Judge.
State, any witnesses or evidence for the court to review?
Yes, Judge. Judge, at this time, I would offer state's constitution just for the purposes of this court's review and steering.
I have no objections.
Okay. States exhibits 1 and 2 are admitted for purposes of this hearing. And the court will review.
I lost mine, lost, but I also got previous one ready. Where is it? Sorry, Contentreference 2025. Seal 012282. Oaicite.
All right, the court has reviewed State's Exhibits 1 and attachments. Any other evidence?
No other evidence.
All right. Defense, what amount? I'll just figure out what amount you're asking for and then I'll hear argument.
Well, Judge, I can tell you, I was a bit taken aback by the sheer amount of charges that were filed because I think the previous discussions didn't quite encompass all of those. I mean, obviously there's a bond schedule in place, but I'd ask the court to look to the low end just based upon the sheer number of counts that were filed. I think a lot of those are probably going to go away. I'd ask the court to set bonds on each charge at 25,000. I think it'll be hard for them to make it, but it still gives them an opportunity. I don't think there was GPS in place before, but that might be appropriate in this circumstance if the court is concerned about safety to the community.
State,
Judge, is this court setting bond by case number or by county?
case number.
Case number?
Yes.
That's the cumulative bond on the case be 150, with full GPS if released.
Well, if it's all in one case, then I'd ask the bond be set at 100.
All right. And I'm saying all in one case because it makes it easier for the clerks.
Sure.
And so this is under cause number 2025 CR 01327. And what I can tell you, Mr. Dreamer, according to new case law, you're not entitled to bond, but I haven't received the evidence on the previous allegation of the assault family violence to make a decision to deny you bond. But this is what the court will do. There's to be no contact with the complainant. There's to be full GPS, waive fees, and the court will set your bond at $200,000. And I need a date for discovery on this case, please. And counsel, I know the previous discovery date on this case was today, but you've been in jury trial.
Yes, ma'am.
All right, so if we could do a discovery date for that last week in December.
I'll be here.
All right, so your discovery is going to be December 18th. And if someone, I'm going to give you all a blank form. If on the blank form, if you could write down the court's ruling with regards to the bond motion so that the clerks may have it.
Yeah. No, post bond. No, I can look it up. You'd be the one here. No.
All right, could you grab that from the printer, please?
Yes.
And counsel, if your client can just sign that acknowledging that he's on notice,
Yes, ma'am.
and if all parties will sign that. All right, if everyone can please whisper. Court is calling 2025 CR 010818, State versus Julian James Montez Jr. Can I have parties announce?
Bob Brobach for Montez.
And are you Mr. Montez? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Montez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Montez, did you review court's admonishments with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? You're charged by indictment with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to present you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's mentally competent.
I'm sorry, if I could have that trial court certification back. Thank you. Mr. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the country. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $1,000 fine, and the state is silent on your application. Did you understand that to be the plea?
Yes, sir.
Defense,
Yes, ma'am.
state?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, see off receipts, exhibit 1 and all attached.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? State, you may be excused. Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to request a PSI and TAP evaluation, it will take approximately 8 to 12 weeks because there's a backlog.
Yes.
And, or if you want, he can be brought back sooner, probably in about 2 weeks, and you can bring whatever evidence you want the court to consider.
We can come back in 2 weeks.
All right, and you're waiving PSI?
No, I think we want a PSI. I
All
think
right, so then that's 8 to 12 weeks.
we'll do the PSI.
All right, I need a date for PSI and TAP.
January 8th.
All right, we'll see you back on January 8th. At that time, I'll make a decision on your application based upon whatever evidence is presented to the court. All right, thank
You
you.
judge.
Have a seat, sir.
Right. So how are you doing today? Okay. All right, so on this case, where are we on discovery?
Your Honor, this time it looks like we are missing quite a bit. I'm not sure that I need to get it completely. I think we have it. I just need to get it. But it is a surveillance video and it is phone extraction and multiple computer extractions.
All right, and then is there any CPS records?
Yes, Your Honor. Yes.
Any school records?
Your Honor, in this case, there are 6 different victims. So I don't have any school records at the moment. Defense has not requested.
Are you going to be requesting school records?
Your Honor, I don't know because I haven't gotten the discovery to start off with.
School
got-
records?
Mhm.
So if there's school records, is there any type of therapy records? Just make sure they're available.
Your Honor, one other thing
Mhm.
is in any type of sensitive case like this, I always have my client watch the forensic interview with me.
Mhm.
And we want to arrange a time and maybe during the holidays, it may be a good with that, when you don't have a jury, that Mr. Casares can be brought over, but in the jury room to allow us to watch it or
Yep.
stay in the courtroom if the courtroom is clear.
You'd have to make an arrangement with the deputy, so speak to them about the scheduling issues, because they will be in charge of security. And if
Mhm.
you all will both get a date from them.
Your Honor, one thing that came up is the state wants to be present during the time that my client and I watched the video.
Why?
I've never had anybody, the state present. I've had the deputy present.
Sorry about that, sir.
Oh, no, it's okay.
We never discussed this yesterday with a different case, and that was a solution that came up. So like I told the defense counsel, I don't mind asking it whatever way. I'm totally fine with that.
Okay, great.
Mhm.
Yeah, and if we can do it, yeah, but yeah, the holiday may be a good time because it's a little without a jury,
Okay.
so we can get that
All
scheduled,
right,
Your
but
Honor.
what I can tell everybody is if there is an issue with her and her client being allowed to view it alone, and when I say view alone, the deputies will have to be here because he's in custody. But if there's another issue, we can have a hearing on it. And what I can tell everybody, I don't think that it is appropriate for the prosecution to be present when a defense attorney is reviewing evidence with their client unless the defense attorney has no objections to it, because maybe they want to discuss issues. Now, because your client is in custody, the deputies will be present because they're in charge of security.
Mhm.
Yes, Your Honor, and I
Yes.
think that was more to, if we couldn't get a jury room and we had to do it upstairs in our conference room. So we just need to work out logistics.
Mhm.
All right, thank you. Ms. Ferguson, I need a reset for discovery. If you can set this in late January.
Yes, ma'am.
Seems like a good day.
All right, thank you. And then if you'll discuss with the deputies a date to have him brought over to view videos.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome. 663, State versus Imani Robinson. Could I have parties announced for the record?
David Andre Woodard for Imani.
And are you Miss Robinson?
Yes, ma'am.
All right, defense, you're here requesting a bond, is that correct?
Correct, Judge.
All right, and defense, what bond amount are you requesting, or is there an agreement? I'm sorry? All right. Ms. Abrams?
Yes.
And state you may be excused. On this case, she's currently on probation. Is there any conditions that need to be added as far as any no contact orders, any mental health or drug issues that need to be addressed with the bond? Twenty 2024 CR 008663.
Get monitored. It's the allegations for failure to report.
Okay.
And Judge, I don't show that there's any type of conditions for anything of mental health.
All right. Thank you. Has your client, since I've last seen her, has there been any type of mental health issues, any mental health diagnosis?
Not to my knowledge, Judge.
No. Okay. Just one moment.
No, Judge, she doesn't wish to speak.
All right. There's going to be, the court will follow your agreed order. There's a $7,000 bond, full GPS waive fees. There's to be no contact with the complainant. And the court's order is to be entered on November 21st state. And the reason why it's November 21st is because the complainant needs to be notified that she'll be released. If you're able to contact the complainant today, then it can be entered into the system today. All right. And then Ms. Ferguson, if you can set this, counsel, do you have all of the discovery?
I don't, Judge.
All right. Norma, if you can set this for the first week in December. All right, it'll be set for December 4th. And probation, that's for them to obtain the discovery. All right, is there anything else?
No, Your Honor, thank you.
Right, and if you'll check with the state and come back to me on whether or not the order should be placed in the system today or tomorrow.
Okay, thanks, Judge.
All right, thank you.
It was, Judge.
Yes.
And the results were same? All right, and you have all discovery?
While we were waiting for the evaluation, I did go through the biopsy. We were missing anything. It turns out we were missing DNA and serology labs from Texas DPS private laboratory, so I did put a rest on those things. So this woman, and do use it, would be at least 60 days.
Okay, so the court has a hard time understanding with the nature of the case, why anybody didn't think there should be DNA.
I think so, Judge. The easiest thing would be just order to exclude it and then we could.
All right, this is going to be set for jury trial and the plea deadline date at the same time. How long do y'all expect this trial?
At least 4 or 5 days, 6 days.
All right, Norma, I need a jury trial date, 4 to 5 days. And this needs to be set no later than February.
The courts indicated that if we're at trial and those results aren't back, that obviously they would be able to support it.
Oh, I mean, I'll hear
Okay, all right.
Yeah. and make my ruling.
You do the February 10th.
All right, February 10th is going to be your jury trial date. What I can tell you, counsel, I don't understand. We've been on this case since March, and it shouldn't take a year to obtain DNA evidence.
I agree. Judge.
Otherwise, something shouldn't be indicted. Yeah. It's like, don't indict it. All right, so we're going to be back for a jury trial date and a plea deadline date on February 10th, 2026. So everybody be expected to go. Ms. Sinwell, you'll be brought over dressed for trial. You'll be dressed in whatever clothing whatever civilian clothing you have at the jail. If you wish to be attired in something differently for trial, you'll need to do a clothing exchange. Counsel, my understanding, the jail has changed that. So you need to have her clothing exchange done within 72 hours of trial.
You mean before 70 hours before trial? Judge? Okay.
Yes. All right, thank you.
Thank you, Your Honor.
You're welcome.
Have a seat, ma'am.
I have one more, Judge. I think it's on the same.
All right, who is,
On page 8, Judge, just one down, Danny Reader.
Have a seat.
all right, have a seat.
Oh, here's the discovery acknowledgement.
Thank you. Look, you are anticipating. I appreciate that.
Judge, the state has made us an offer and we're not declining it. My client has a job in which he's working 6 and 7 days a week. We're sort of contemplating things. I also opened up their file today.
Okay, I'm sorry, I cannot hear.
Oh, I'm sorry. And then I also opened up the state's file today and there's several disclosures about officers being under investigation. So I need to look into those sorts of things too.
All right, state. Disclosures concerning officers.
I'm sorry, on Joseph Rodriguez, there are a number of disclosures in that. I was on the deadline looking at what this one. So,
So make sure they're available for him.
The disclosures are in the file. If you think you need something more than what's in there, then just let us know. We'll work on it.
All right, Norma, set this for a plea deadline date in December. This will be your final plea deadline date. The court will not extend plea deadline date further. Norma, if you'll just put it on December 9th as well.
okay.
All right, is there anything else? Do you have any questions?
No, ma'am.
All right, thank you. Just have a seat. Once you sign the reset form, you're excused.
Thank you.
You're welcome. All right. So what is happening with this case?
Judge, an offer was made today, conveyed today. My client would like a little bit of time to consider that offer.
All right, Norma, set this for the first week in December. That will be your plea deadline date. The court will not extend it any further. All right, we'll see you back on December 2nd.
Thank you, Your Honor. Appreciate it.
All right, thank you. Once you sign the reset form, you're excused. And if you could make sure I have the acknowledgement of discovery.
I will, Judge. Thank you.
All right, thank you. All right, and is Luis DeLeon out?
Not yet, Judge.
All right, thank you. Good morning. So he's in a state of crisis. My understanding, there are some misdemeanor cases.
Just informed by probation, but I had, as you know, I can only contact Don.
Yes.
They had tried to get him to go to appointments. We were scheduled a couple of times and unfortunately now he's in custody. So I will set a bail visit, but I wasn't sure if you wanted me to approach on this status. So
Well, on this case, based upon the information that you all have given me, there's probably going to have to be a competency evaluation, which I anticipate he's going to be determined to be incompetent. And then we're going to have to wait for that to resolve itself. So this is probably going to have to be set in the new year. And if, council, if you discover something in December, that means he's confident and ready to proceed. Just let the court know, we'll make that happen. But there's nothing I can do.
I understand, Your Honor. I just, since he was on the docket, I wanted to. approach.
No, I appreciate it. And I regret that there is not a hospital or any of that, because he probably needs long-term care to address the mental health issues. So we'll set it in late January. I need a late January date. All right, and it will just be for status council.
And Your Honor, I'll
Mhm.
move them. And of course, I will file the competency as soon as I have them.
Okay. All right, and could you reach out maybe to his brother and let him know?
Of course.
And I don't know if that's an appropriate placement anymore. Not that the brother's doing anything wrong, but I don't think he's equipped to make sure he takes his medication and all of that. All right, thank you. Hello. All right, today's plea deadline date.
Judge, there's additional discovery that we need. There's evidently some CPS records out of New Mexico. So state said that they would subpoena to get those. But we need a little more time.
Yes, previously we have the CPS records from Texas, and we have disclosed those over to defense. Defense pointed out that we had some records today, so I went ahead and sent a request for those to be approved.
All right, Ms. Ferguson, I need a jury trial date and a plea deadline date. Put this in February.
Yes, ma'am. Let's do February 24th, Judge.
All right, February 24th, you'll either reach an agreement or either you will be in jury trial.
Thank you, Judge.
Once you sign the reset form, you are excused. Thank you. Hello, Mr. Perez. I'm doing okay. How are you doing? All right, what is the update on the mental health evaluation?
Judge, may I comment on that?
Yes.
I just reached out to Lori because I had done the application online for the assistance from the MAC and they didn't respond. So I finally spoke with Lori, maybe a few days ago. And I filed a motion for the mental evaluation and they're gonna get back with me on that. I'm not sure how long that process will take. But he's
Right,
gonna-
Norma, can you call the magistrate's court, ask them if they received the evaluation? Because the court has already signed it.
But we had kind of discussed that strategy going forward either way, Judge. I just filed a motion to be absolutely certain that's done.
Okay,
I apologize for not being here on Monday.
no problem.
Or no one's answering.
All right, set this for January.
What section?
Yes.
Let's do January 12th.
All right, they should have information on your competency evaluation at that time. Thank you. Do you have any questions about anything?
No.
All right, thank you.
Thank you, Judge.
You're welcome. All right, and Rick, are you all handling both cases?
And Hunter Morris is here on the other one.
All right.
Oh, I'm sorry.
Hunter?
No, I'm sorry. No, I'm sorry. Wrong.
Oh, wrong
That's my,
person.
never mind, Hunter.
All
CTD is handling the felon possession.
right, but Hunter, we still appreciate you. All right, so today is a plea deadline date.
And we're gonna reject that. We'd like a trial setting.
All right. So how long do y'all expect this trial to last?
I'd say so.
I'm sorry,
3 days.
3 days. I need a jury trial date, 3 days, and counsel, if you'll make sure you do an acknowledgement of discovery.
Yes, ma'am. I'll work on that.
February tenth.
Is this us, Robert?
No, I'm putting this down. I'll get you out of here in a second. I'll meet you down.
Oh, okay.
That's the next one.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Thank you.
Oh, I was just hanging to see when Mr. Dreamer. gets
Yeah,
reset.
I'm gonna put that on the. No, I'm gonna do that. I'm gonna put this on there.
Right.
Okay.
So on this case, do you have all the discovery?
No, Your Honor, and we've made an appointment for 1:30 on Monday to review a video that the nature of the video is such that we can only view it in the DA's office.
And
And
that's the only discovery?
I believe so, Your Honor. What I want the court to understand is that it could be dispositive on the video when we view it. I don't want to say too much.
Mhm.
But I think you understand what we're talking about. And if we need to try the case, we're probably going to request some CPS records.
No, the CPS record should have already been turned over
Okay,
because that was, you also, or either the court mentioned CPS records in September. So you should already have CPS records.
okay. I'll check with Mario, my co-counsel on that, Your Honor. You could be correct.
Hmm.
So, but we're gonna, on Monday at 1:30, we're gonna view the video.
All right, Ms. Ferguson,
Yes, ma'am.
set this for the second week. Y'all will need to confer off docket. Set this for a second week in December for a plea deadline date.
December 11th.
All right.
And we will get an email on that, Your Honor.
Oh, however he's gonna have to sign a reset form.
Okay, thank you.
All right, thank you.
Sure, you can wait in the gallery. Thank you. And have your client sign it and bring it back to me and I'll give him copies.